You have an offense back. June 5th. Occurring on June 5th, 2025. How do you plead?
No contest, Your Honor. Contest?
You understand that by pleading no contest, you will not have a trial of any kind?
Yes.
All right. You signed an advice of rights form in each of these cases?
Yes.
Do you have any questions regarding any of those rights?
No, Your Honor.
Look on the podium, you'll see a copy of one. Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
Nope.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And because, well, I won't ask that part. The court has been provided and has reviewed in the case ending 5670, University of Michigan Department of Public Safety report for their case number 2490305419. And in the other matter, Ann Arbor Police Department report for their case number 2431255. Any objection to the court having reviewed those reports?
No, Your Honor. No, Your Honor.
Based upon a review of those reports, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel? Well,
civil
before I
liability.
do that, sir, I do have to advise you that if between the time of my acceptance of your plea and your sentencing, if you commit misconduct as defined by the Michigan court rules, that you would not be entitled to withdraw your plea. I also need to advise you that any sentence agreement, evaluation, or recommendation, the court would no longer be bound by. You understand that?
Yes, Your Honor.
You do?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have caused this plea?
No, Your Honor.
All right. And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Your Honor, it's a no contest plea for civil liability. I don't think.
Thank you.
Okay.
All right. I did not ask.
Yes, Your Honor, people are satisfied.
Defense is now satisfied.
Court will accept the defendant's no contest pleas to count 2 in both of these cases. Count 1 is dismissed. You're going to get 2 sentencing dates, and you're going to have to reconcile them. Pre-sentence investigation and reports are ordered at 15th District Court. In case 5670, sentencing will occur
August 26th at 9 a.m.
August 26, 2025, 9 a.m. before Judge Valvo. In the other matter, sentencing will occur
August 28th at 8:30 a.m.
August 28th, 2025, 8:30 a.m. That is before Judge Perry. Bond in each of these cases will continue.
Thank you, Your Honor.
I need those. I don't know why he can have those back. I don't need the extra paper.
Thank you.
All right. You okay? Court calls the case People versus Anitha Barnes.
People.
This hearing isn't about justice anymore. It's survival. Fines, fees, and late charges swirl together like legal soup, and everyone's pretending it doesn't taste bitter.
Beneath the barn.
Can't find a feaster when you need him. Really, you sat here all morning. I called your case and you weren't here. What are you?
I had to go eat some apple juice.
What?
Sorry, Judge. I wanted to taste my breakfast. My apologies.
Seriously?
I apologize, Judge. I don't know.
Go ahead.
I am here.
Ma'am, could you please state your name? Because
Anitha Barnes.
thank you. Because
Thank you, Judge.
feasters are mess. Anyway,
You should have a green sheet in your
I
file,
do.
Your Honor. Ms. Barnes and I were unable to connect. I know we're trying to get this matter resolved. Hopefully she'll be able to give us a call before the next pretrial date, PCC date, and we can hopefully get this matter moved forward.
Probable cause conference, August 28th, 2025, 9 a.m. Bond will continue. All right. Thank you, Ms. Barnes.
Thank you, Judge. Sorry again.
No. Enjoy that apple.
I'll wait for my apple.
No, go. Please eat it. There's nothing like looking at a half-eaten apple that like makes my day just go forward. Go ahead, finish your breakfast.
I'll be right there.
All right. We know where to find you. Court calls the case. People versus Savannah Crittenden.
Good morning, Your Honor. James Fifelski, standing in for Attorney Robert Ellman on behalf of Ms. Crittenden.
Andrew Childress, appearing on behalf of people.
Ma'am, you have any objection to Mr. Parkowski standing in for your counsel of record?
I don't, Your Honor.
All right, very good. What are we doing?
Your Honor, we are asking the court to set this for a preliminary examination.
Discovery, to your knowledge, is complete.
Yes, Your Honor.
People have their witnesses available the 19th. Preliminary examination in person, August 19th, 2025, 9 a.m. That is before Judge Moore. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case of People versus Roderick Bates.
For Douglas for the people.
Serious? And I don't.
Where the judge?
You didn't even finish the apple.
I'm working on it.
What?
Like 4 more bites taken out of it.
Smile.
Working on it.
You got like small teeth or something.
I do.
You should have been done with that, right? Shanaz?
You're supposed to chew
He should have been done.
isn't it like 20 times for each bite or something?
I
Take
don't
some
know. I
time.
don't know how to eat that apple, but it's still here.
Torshell Feaster, assistant public defender, on behalf of, but apparently not with, Mr. Bates. We did try to reach out to Mr. Bates by email and by phone. We did not receive any response. For the record, I would request an adjournment, but I have no idea where Mr. Bates is.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately.
Thank you, Judge.
Thank you.
I'll try to get it.
Yeah, go finish. Let's play a joke. Let's call it feaster day. No. Court, listen. Okay. The court calls the case of the People versus Ryan Carter Price.
Viewers, people,
And Assistant Public Defender Shanaz carry out Your Honor on behalf of Mr. Ryan Carter Price, who's approaching. Mr. Carter Price, state your name for the record, please.
Ryan Carter Price.
Thank you.
Judge, we're asking that this matter be set for preliminary examination.
Discovery is complete.
To our knowledge, Your Honor.
People have their witnesses available the 19th. Preliminary examination in person, August 19th, 2025. Time. 12 noon, that is before me.
Thank you, Your Honor.
Bond will continue. Thank you. Court does call the case of People versus April Black.
people.
Stephanie Cannon on behalf of Ms. Black.
Oh, wow. Where have you been? Where have you been? That's my way of saying I missed you. Not really. Don't get all sappy. We just missed you because it was quiet.
I've been good, Your Honor.
Okay.
Well, trying. Your Honor, we're just asking for a brief adjournment in this matter. I have litigation information we're hoping to use to resolve this short of trial.
Probable cause conference will be adjourned August 28, 2025, 9 a.m. Bond continued. Thank you, ma'am.
Thank you so much, Your Honor. And a contact picture.
Court calls case People versus J. Dingman.
Assistant Public Defender Chelsea Vergils with and on behalf of J. Dingman, who approaches. Mr. Dingman, please state your name.
J. Juan Dingman.
Please sign your referral to treatment court. Your Honor, we're asking for an adjournment today for referral to mental health treatment court and ask the court to sign the referral form. I would also ask to address bond when appropriate.
Of course you would.
You can feel the judge's exhaustion radiate. She's not mad, just disappointed, like a mom catching both sides lying about who really broke the house.
Do we know how long they're operating before they do anything and make their assessment?
I don't know, Your Honor. In my experience, it's been a couple weeks, but I don't know for sure.
Yeah, okay. Well, let's at least give it a shot so you can just sit there out. Pardon? 3 weeks. Okay. I'll then adjourn this out to August 28, 2025, 9 a.m. as to bond.
Your Honor, we are asking you to consider a personal bond today. He does have a permanent address in Ypsilanti. He has the support of CMH, who he's been working with long-term, as well as his family. He asks to await his decision about treatment court out of custody, if you would consider that.
All right. Response on the people.
Your Honor, we do not think that would that's for Mr. Dingman. He did fail to appear at his last court date. We note that the reason we believe that mental health court may be appropriate for Mr. Dingman is because he does struggle with mental health issues. He has been with long term, but we would know that despite that, he still has picked up this case, which we do think the description has a lot to do with his health status. So, Your Honor, we do not think that Mr. Dingman on his own is able to procure when required to do so. So I think that if he was just released, we wouldn't see him until we don't know what time. So, Your Honor, I would object to release on a personal bond unless it was with a tether to inpatient treatment.
Right, but there's not been a request for inpatient treatment. Certainly, I would consider that if that were what was being asked, but I don't think that's what's being asked of the court. The motion for bond modification and/or reduction is denied. The defendant already has a record of failing to appear before the court. His bond will continue as set. Thank you.
Thank you, Your Honor.
Court does call the case People versus Daniel Bowe.
We're here waiting for the people.
Good morning, Your Honor. Assistant Public Defender Alexis Zerps on behalf of Mr. Bowe. Mr. Bowe, can you please state your name for the record?
Daniel Bowe.
I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
All right. The plea form indicates that the defendant will be pleading no contest to the charge of retail fraud in second degree, the 1-year offense. Upon the successful plea to that charge, count 1 would be dismissed. There is also the agreement of restitution in, well, it says the amount of no dollars.
That's correct, Your Honor. There's no restitution necessary for this case.
So why is it on here? Anyway, never mind. All right. Hey, have him sworn.
Do you solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Lower your hand and then state.
Daniel Bowe. DANIEL
All right. Sir, it is this court's understanding you're going to plead guilty to, or plead no contest to the charge retail fraud in the second degree. That's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property stolen. If that's greater than $2,000, that would be the maximum fine. You understand that?
Yes, sir.
Do you understand what a no contest plea is?
Yes, sir.
All right, 2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. Do you understand that?
Correct.
Second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Correct.
And you also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court. You understand that?
Yes, Your Honor.
All right. Basis for the no contest plea?
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
Guilty. Or no contest.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
You almost blew it.
I know.
All right. You don't have any.
I don't get sleep at night. I got a newborn at home, so my mind's everywhere.
You got a newborn at home?
Yes, sir. Yeah.
Okay, we'll get to that. Is that your first one?
No, it's my second. My other one's 15.
Then you're that's old school for you then. All right. You signed an advice of rights form. No questions regarding those rights?
Correct, sir.
Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights of that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Correct.
Are you on probation or parole?
Yes.
But he was not at the time.
Oh, no.
Not at the time of the offense.
No.
Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily?
Correct.
Of your own free will?
Yes, sir.
And because you believe that you are, well, I won't ask you if you prove that you're guilty. Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 249721. Any objection to the court having reviewed that report?
No objection, Your Honor.
Court, upon a review of that report, does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if I do accept your plea, and if between the time of this acceptance of the plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence recommendation if there were any in this case or evaluation, and you would not be entitled to withdraw your plea. You understand that, sir?
Correct, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements that have caused this plea?
None from defense, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be
October 6th at 9 a.m.
October 6, 2025, 9 a.m. That is before Judge Freshour. Bond will continue. Congratulations, young man. Boy or girl?
Boy.
Boy?
Yeah, he just don't sleep at night. He's an angel during the day, but when it comes to nighttime,
That's how you got in trouble. So the apple doesn't fall far from the tree. All right.
Thank you,
You take care, young man.
Thank you, Your Honor.
Court calls the case, People versus Cedric Green.
Ready, Judge?
Wow.
Court shall please the Assistant Public Defender on behalf of Mr. Green. Mr. Green, please state your name for the record.
Good morning, Cedric Green. Thank you. No apple?
I finished.
Did you finish?
I did finish it.
Took you long enough. All right.
Slow eater. Sorry.
What are you doing?
Mr. Green has asked that I accept this matter for preliminary examination. I believe all discovery is complete.
And people have their witnesses available the 19th.
Yes, sir.
Preliminary examination in this matter will be set August 19th, 2025. Set at 9
a.m.
a.m. before Judge Moore.
Thank you very much, Judge.
Bond continued. Thank you. Court does call the case of the People versus Zaria Brand.
Ally Zend on behalf of the people, Your Honor.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Zaria. I'm sorry,
Told you.
Zaria Brand.
Your name, ma'am?
Zaria Brand.
Zaria.
Your Honor, we do have a resolution. There's one outstanding issue that I just asked Ms. Zenda about a few minutes ago. So we have the paperwork, but we're going to look into that one issue. So I am asking for a brief adjournment. I think 2 weeks would be correct.
Probable cause conference, August 19th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you, Your Honor.
Court calls case People versus Khalil Haddon.
Assistant Public Defender Alexis Zerps with and on behalf of Mr. Haddon, who's approaching.
Here's the legal irony. Everyone agrees repairs happened, but no one agrees if they're real. It's Schrodinger's renovation, both complete and incomplete until the city says otherwise.
Can you state your name for the record, Mr. Haddon?
Kahil Jabron Haddon.
Thank you.
Your Honor, we're requesting an adjournment for some further discussions.
Requesting an adjournment.
Yes, Your Honor.
Okay. Probable cause conference without objection, August 19th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case People versus Jamie Burke.
If you ever to move this for people.
Matthew Mansour, Assistant Public Defender, on behalf of Mr. Jamie Burke. Jamie, can you please state your name for the judge?
Of course. Good morning, Your Honor. Jamie Burke here.
Thank you.
Of course.
Your Honor, we're going to be requesting an adjournment, please, to satisfy the restitution amount. And
how long is that going to take him?
The longer, the better, Your Honor, but I'll leave it up to your discretion. Maybe.
Currently, I'm doing Uber, word of mouth Uber, and
okay,
and then doing trades with electronics to like pawn shops and things like that, buying them from. So I'm getting money slowly, and I just applied to a hotel this morning as well. So
we'll take a month, Your Honor, if you could,
if I can. So I can at least get the funds up, if I may, Your Honor.
Is he going to be able to do it in a month?
Absolutely.
Probable cause conference will be adjourned September 11th, 2025, 9 a.m. Bond continued. Thank you.
Thank you very much, Your Honor. I really appreciate that.
You're welcome.
I hope you have a wonderful day.
You do the same.
Thank you.
Court calls the case People versus, is it Jervapko Hitana? Ms. Willingbring, I guess was the prosecutor.
Advisor, we have to keep the unnecessary.
Oh, okay.
Assistant Public Defender Chelsea Vergils with and on behalf of Zdravko Kitinov. Can you state your name?
Yes, Stratford Kitsenov.
All right.
Your Honor, today my client would like to waive his right to a, I'm sorry, can you sign right here? His right to a preliminary exam.
Have discussed it as the first creature enter that plea agreement, we would not be remanding for the preliminary exam.
Sir, you're waiving your right to a preliminary examination?
Yes, Your Honor.
Is that what you're doing, sir?
The plea agreement is on the table, I believe, still.
Yes, that's what she said. That.
Okay.
Then, yes, Your Honor.
Plea agreement to obviously some felony charges that would take place in circuit court.
Yes.
So to accomplish that, are you waiving your right to a preliminary examination?
Yes, I'd like to take the plea agreement.
Pardon? Okay. Well, I have to make sure that you understand that a preliminary examination is a proceeding where the people would have to show by a standard of probable cause that the offenses alleged were committed and that you committed them. You understand that?
Yes, Your Honor.
All right. My understanding is that you're waiving or giving up that right to have that hearing and proceeding to circuit court for further resolution, which may include a plea agreement.
Yes, Your Honor.
All right. Is that your understanding?
Yes, my goal is to take the plea agreement. So, yes.
All right. But you understand you'll not have a preliminary examination. I just want to be clear on that.
I understand.
All right. The people have indicated they also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on all 5 counts. Your turn.
But I cannot be taken.
We would acknowledge receipt. I'm sorry. I was momentarily distracted. I apologize, Your Honor. We would acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant has waived formal reading, standing mute. Court will enter not guilty plea as to all counts. Pretrial in this matter will be set for
August 26th at 1:30 with Judge Kunke.
August 26, 2025, 1:30, Judge Kunke.
Thank you, Your Honor. If I may approach to sign the following information.
Yes, we'll bring that over to you. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case, People versus Bradley Chavez.
Andrew Childers appearing on behalf of the people.
Matthew Mansour, Assistant Public Defender, on behalf of Mr. Bradley Chavez, who should be appearing by Zoom. Bradley, can you please state your name for the judge?
Bradley Chavez.
I have before me a plea form. Is that what we're doing?
That's correct, Your Honor.
Plea form indicates that the defendant will be pleading guilty to an added count to use of methamphetamine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. There is also no objection to seeking 7411. That's the court's full understanding of the agreement.
That's correct.
That is correct, Your Honor. Thank you.
All right. Chavez, could you please raise your right hand?
Yes, Your Honor.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right. State your name again for the record.
My name is Bradley Chavez.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
And you also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, I do.
Still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
I plead guilty, Your Honor.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes, I do.
All right. You signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. You understand that you're waiving those rights as well as other rights on that form?
Yes, I understand.
You understand you're giving up your right to appeal of right?
Yes, I do.
Are you on probation or parole?
Yes, I am.
All right. Were you on probation at the time of this offense?
Yes, I was on probation during the time of the offense, and I was actually this was brought up in that court case. So I did have to turn myself in and serve time for that offense for violating. That was back in December, so that court is aware of that violation, and I did do time for that.
Okay, well, thank you for all of the information. I do also have to, though, advise you that if it is considered a violation, that court could sentence you to the maximum allowable under that other charge. You understand that?
Yes, Your Honor.
And you still wish to plead guilty to this charge?
Yes, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of July 26, 2024, at the location of State Street near Dewey, City of Ann Arbor, Washtenaw County, State of Michigan, did you have methamphetamine in your possession?
Yes, Your Honor.
Had you used it?
Yes, Your Honor.
Did you know what you were using was methamphetamine?
Yes, Your Honor.
Counsel, sir, I do have to advise you that if between the time of my acceptance of your plea and the time of your sentencing in this matter, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and any sentence recommendation or evaluation the court would no longer be bound by. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. Thank you.
And has the court complied with the court rule? Would it be proper to accept this defendant's plea of guilt?
Defense is satisfied as well, Your Honor. Thank you.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
September 12th at 8:30.
September 12, 2025, 8:30 before Judge Perry. Bond continues.
Thanks, Your Honor.
Thank you.
Do I have to check? My bad.
Pardon?
I was gonna say, do I just have to check in with the 15th District Probation Department now?
Yes, sir.
Okay, all right. That's all I want to know. Thank you, Your Honor.
Thank you. Have a good day.
You too.
Court calls case People versus Kristen Knight.
Dr. Douglas for the people.
Stephanie Can on behalf of Mr. Knight, who is approaching. Mr. Knight, when you are at the left turn, please state your name.
Christian Knight.
Thank you.
And Your Honor, at this time, we are going to ask for a preliminary exam.
All discovery is complete.
Yes, Your Honor, to my knowledge.
And would the people have their witnesses available the 19th?
Your Honor, we will do our best.
Preliminary examination in person, August 19th, 2025. 9 a.m. That is before, is it 9 a.m.? 12 noon, that's before me.
Thank you so much, Your Honor.
Thank you. Bond continue.
Oh.
Court calls case People versus Deshaun Clifton.
Dr. Douglas for the people.
And Stephanie Can on behalf of Mr. Clifton, who is approaching, Your Honor. State your name, Mr. Clifton.
Sean Clifton.
This is what we call a show cause hearing. Basically, the judge's version of explain yourself or else. And right now, the or else feels very real.
And Your Honor, we are negotiating on this. We've been back and forth. We're just asking for some additional time to see if we can reach a resolution short of a preliminary exam.
August 28th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court does call the case of People versus Derek Coleman.
Alexander on behalf of the people, Your Honor. Assistant Public Defender Alexis Derbs on behalf of Mr. Coleman, who's approaching.
Your name, sir?
Derek Coleman.
Thank you.
Your Honor, we respectfully request that this be set for preliminary exam.
Discovery is complete.
To my knowledge, yes.
Preliminary examination in person will be set August 19th, 2025. That's 9 a.m. before Judge Moore. people would have their witnesses available. I should. All right, thank you. Bond will continue.
Thank you, Your Honor.
Court does call the cases of the people versus Jacqueline Murray.
Andrew Childress appearing on behalf of the people.
Matthew Mansour, Assistant Public Defender, on behalf of Miss Jacqueline Murray. Jacqueline, can you state your name for the judge when you're ready?
Jacqueline Murray.
Hey, what are we doing?
Your Honor, there should be a plea form, 2 of them in there. We have a resolution.
Yes.
What would be the 15th district court files?
Yes.
Based on the court's acceptance of on those that people would file an Ollie Cross on the 14th.
Thank you. All right. Very good. All right. And they are both, the defendant's going to be pleading to count, well, in the case ending in 5597, it would be count 3 of use of fentanyl, with counts 1 and 2 being dismissed. And in the other matter, it would be count 2 of use of fentanyl, with count 1 being dismissed, as well as the case ending in 622. Both of those 1 years. That's the court's full understanding of the.
Perfect, Your Honor.
May I have her sworn?
You solemnly swear or affirm the testimony you're about to give the whole truth and nothing but the truth, so be God.
Yes.
Lower your, say your name.
Jacqueline Murray.
All right. Ms. Murray, it's this court's understanding that you're going to plead to 2 charges of use of fentanyl. Those are misdemeanors punishable by up to 1 year incarceration or $1,000 fine plus court cost. Do you understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo and Judge Perry, respectively, in the 15th District Court. Do you understand that? All right. And understanding that, you still wish to plead to these charges?
Yes, Your Honor.
All right. So to the charge of use of fentanyl contained in the case ending 5597 with an offense date of June 22nd, 2023, how do you plead?
Guilty.
To that same charge contained in the case ending in 5540 with an offense date of October 6, 2022. How do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
You'll see a copy on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yep. Yes.
and because you believe that you are indeed guilty of this offense, of these
Yeah.
offenses.
Yes, Your Honor.
All right. Starting first with the case ending in 5597. Ma'am, on the date of June 22nd, 2023, at the location of Warden Avenue near Dexter Avenue, City of Ann Arbor, Washtenaw County, State of Michigan, did you have fentanyl in your possession?
Yes, I did.
Had you used it?
Yes.
Did you know what you were using was fentanyl?
Yes.
All right. Going to the next one. On the date of October 6, 2022, at the location of 727 Miller Avenue, City of Ann Arbor, Washtenaw County, State of Michigan, did you have fentanyl in your possession?
Yes, Your Honor.
Had you used it?
Yes.
Did you know what you were using was fentanyl?
Yes, Your Honor.
All right. Ma'am, I do have to advise you that if between the time of my acceptance of your plea and your time of sentencing, that if you commit misconduct as defined by the Michigan court rules, that you would not be entitled to withdraw your plea, as well as any sentence agreement or evaluation the court would not be bound by. You understand that?
Yes, Your Honor.
All right. Is counsel aware of any promises, threats, or other inducements which have led to this plea?
None on the defense, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's pleas?
Defense is satisfied, Your Honor. Thank you.
All right. In the case ending in 5597, court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed. I'll just finish up on that case. A pre-sentence investigation and report is ordered at 50 District Court. Sentencing in that case will be
August 28th at 8:30 with Judge Perry.
August 28, 2025, 8:30 before Judge Perry. Bond in that case will continue. In the other matter, the court will, it said so, accept the defendant's plea guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15 District Court probation. Sentencing in that case will be
August 26th at 9 a.m. with Judge Balbo.
August 26, 2025, 9 a.m. before Judge Balbo. Bond in that case will continue. And the case ending in 25 or case ending or in 0622 as referenced on the plea form, that case is dismissed. All right.
Thanks, Your Honor.
Thank you. Court calls case People versus Jermaine Dalton.
Allie Zend on behalf of the people, Your Honor.
Assistant Public Defender Dobby Leba on behalf of Mr. Dalton. Mr. Dalton, could you state your name, sir?
Jermaine Dalton.
And Your Honor, we're requesting an adjournment today. Mr. Dalton indicated to me he'd like to seek private counsel.
He what?
He would like to seek private counsel.
And pants.
Oh, I'm sorry, Your Honor. Do apologize.
I believe he'll be seeking both.
How much time does he need to do that?
How much time do you need, sir?
Honestly, could I have 3 weeks?
Your Honor, would the court be willing to do 30 days in this matter?
The only time I'll grant an adjournment for these purposes for you to see private counsel, private cause conference will be adjourned September 4th.
Thank you, Your Honor.
Thank you, Your Honor.
2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Do you have a green sheet?
Yes, Your Honor. Oh, apologies. I have it in my hand.
Case People versus LaDonta Skinner.
If you were to the people.
Assistant Public Defender Dobby Leba for Mr. Skinner. Mr. Skinner, could you state your name, sir?
LaDonta Skinner.
Hey, what are we doing?
We're going to be requesting an adjournment in order to receive some additional discovery as well as look into some additional matters.
Probable cause conference, August 28th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Court calls case People versus Curtis Damon.
If you were to the people.
Apologies, Your Honor. Lord Yagis, Public Defender. On behalf, but not with Mr. Damon, Your Honor, may I, or may we approach?
Yes.
Sorry.